the NPA, because you just referenced that, the current CEO of the National Petroleum Authority is just joining us in the studio, as well as a private legal practitioner in good standing, Godwin Edudzi Tameklo. Good morning. Thank you very much for joining us.
Good morning to you, Alfred. Good morning to your cherished viewers and now online listeners.
Indeed.
Yes.
Indeed.
And my distinguished learned senior, my friend.
Thank you, DG.
My friend.
Thank you.
There's nobody who knows sports law, football law than this man. Anything GFA related, sports law and everything, I mean, he's a go-to person.
Thank you.
We maintained that relationship for a while.
Thank you.
I want to thank you for the platform. Yes, I know the circumstances under which I have to be here.
Indeed.
So once again, good morning to everyone. That said, you see, aspects of the SML investigation directly impacts on the work I do. Because of the revenue assurance bits in the downstream petroleum sector. Remember that this whole thing is a contract for revenue assurance and the subsequent consolidation of the agreement. And the whole idea to, as it were, audit the petroleum downstream. Exactly the place that I basically sit as the acting CEO. I am aware that my office has been cooperating, and some of my officers have been cooperating with the Office of the Special Prosecutor on this particular SML investigation. A lot have gone on. So in terms of the merit or otherwise, I'm a bit constrained because who knows? I may be called as a witness maybe in this matter. In the sense that, you see, most of the claim relates to whether or not, and from Manasseh's write-ups, and remember that they originated this whole investigation. Manasseh, the Fourth Estate, among others.
Yeah.
And the claim has always been that there was no need, right, for the SML engagement. Because the NPA was already in the process of doing that revenue assurance. Because they're able to generate the data, and we have other schemes in place that allows for the issues of pricing, the issues of ensuring that products are not diverted, among other things. And so, to Manasseh, there was no need at all for the contract. Those who signed it also believe that there was. So far, so I wouldn't want to comment so much into the merit. The only thing I want to say, that a few things strike me when the OSP announced that they are effected some arrests. I found it extremely curious, and here is my curiosity, that some named officers of SML used to work with GRA.
Yes.
The contracting party.
Yes.
In the sense that it appears at the time when the contract was consummated, the CEO of SML used to be a technical advisor to
the GRA.
One wants to find out the nature of disclosures relative to our conflict of interest laws. What were the nature of disclosures that were made prior to engagement? Is it possible that a technical advisor to GRA, upon leaving office, can immediately engage in an activity with a company that, say, obtained a contract at the time that he was working there?
Right.
They have also mentioned that there used to be a lawyer for GRA,
Philip Mensah,
who today happens to, one way or the other, either consult for or work for.
Okay, that's Philip Mensah, former Deputy Commissioner in charge of legal. He's now serving as legal consultant to SML.
And others. That is where I find it a bit curious. At this point, I will hasten slowly in making any imputation of crime or otherwise. What I do know, that there are clear rules on conflicts. So, for instance, today, I act as deputy CEO, I act as CEO of the authority, and you have a situation where I am no longer in that office. A contract that was signed under my tenure, a company that, say, obtained that contract, I am no longer at MPA and now consult for that company, or I now work as CEO for that company. You see, for us public servants, the responsibility on us a bit more higher. We are put in a situation where we need to conduct our affairs like Caesar's wife. You know, there shouldn't be a circumstance where Caesar's wife will get to a point where there will even be rumor that Caesar's wife, Cleopatra, has anything to do with Mark Antony. We shouldn't get there.
Indeed.
You understand?
Yes.
As human institution as we are, maybe with the benefit of time, we would understand exactly what informed the decision by these gentlemen to be related by way of working relationship with a company that obtained some contractual relationship with the Ghana Revenue Authority. More importantly, at the time when the one way or the other worked. Does this suggest some level of insider trading? These matters will be coming up at the right time. But like I pointed out, because of the cooperation between the agency, the authority ahead, and the Office of the Special Prosecutor, I would want to leave the merits, the nots, the have-nots, for the purpose of this discussion.
And I respect that. I respect that. And you talk about some curiosity, something that you're curious about.
Yes.
Is it what you spoke about, or exactly what tickles your curiosity about this matter,
the point.
as it has evolved to this point? Maybe very quickly. I'm not going to indulge you too much.
Yeah, the point I'm making is that imagine me at the CEO of MPA acting. I enter into a contract with a company called Martin Kwebu and Sons Limited, or Martin Kwebu LLC, to do revenue assurance for the authority. Now I leave the authority, okay, and Martin now employs me, right? Employs me as the CEO of the company that obtained a contract at the time when I was CEO. It may not be, but it will create an impression that the contract was prepared ahead of my leaving the authority. Do you get it?
Yes.
And like we always say, a multitude of suspicion is not enough basis to ground criminality.
Yeah.
But that threshold, should we get there? So I am a bit mindful this morning not to say ABC. Look, on the issue of Procurement Act, I think that I have, within the past 12 years, litigated the Procurement Act very well in our court. I've litigated it so well. I've argued many aspects of the Procurement Act. You recall, in the NCA matter, my clients were convicted
I see.
for breaches of the Procurement Act.
Yeah.
I remember vividly before His Lordship Justice Chairperson, when I made this argument that under the Public Procurement Act, a breach does not automatically result in criminality unless you are able to establish a mens rea, because the Procurement Act did not create a strict liability offense so that a breach is a breach. It's like traffic offense. Once you cross the red light, no explanation is enough. Strict liability. My argument was the reverse, that under the 1992 Constitution, you must first establish that at least there is a mens rea and then there is an actus reus. You must establish a guilty mind. You must establish that A, B, C, D. That argument, even though attractive, did not find favor with His Lordship Justice Chairperson.
Yeah.
And therefore proceeded that to the extent that my clients entered into the contract without the approval of the PPA, it constituted their guilt and convicted them 4 years imprisonment. You understand? I remember in the Akuffo Addo matter, Sylvester Animana was also charged for breaches of the Procurement Act. In the Opuni matter as well, and many, many other such. I think that we've possibly gotten to a point where we may have to look at the act again. What's the threshold of guilt? Is it the mere fact that a contract was signed into without? If that is the law, like somebody said, the law is the law.
The law. We know who said that. Yes.
You understand? That's one aspect of it. Is it an evolving legislation that we begin to appreciate its learning and the evolution of our procurement laws? So that, for instance, Section 90 of the Public Procurement Act provide a mechanism for redress. So I remember one of the arguments that I made before His Lordship Justice Chairperson, because my clients at that time, Director General of the organization, entered into the contract. So the argument I placed before him was that, look, in the wisdom of the maker of the law, the fact that he provided a procedure for cancellation ratification in the law means that he envisaged a situation where a contract can be entered into without PPA approval and therefore can go for ratification. And that is why the legislator made that provision. And so if we've not gotten to the point where an opportunity, say, for rectification, cancellation, and all of those things, where the PPA will constitute a committee to investigate the alleged breaches and others and recommend whether the contract should be rectified, or cancelled, the point of criminality has not arisen.